Okay, we're recording. So this is the webinar sponsored by my firm, the Morgan Law Firm. The webinar is on the topic of 5 keys to a fair property division in your Texas divorce. And I am Scott Morgan. I'll be your presenter today. And why don't we just go ahead and get into the material. So, as I said, I'm Scott Morgan. I am a board-certified family law attorney. I have practiced family law in Texas since 1994, and I handle family law cases exclusively and have handled several hundred divorce cases over the years. Bottom line to all that, this is my area. This is what I know about, and I hope to share with you some pointers on how to best handle your divorce case so you can get a fair property division. As I mentioned here on the slide, we have offices in Austin and Houston. I primarily work out of the Austin office, although I spend a good bit of time in Houston as well. And I have another attorney, very good family law attorney, that works primarily in the Houston office. Her name is Colleen Kinsler. But as I said, I work out of both offices. So I am a lawyer, so we got to have a brief disclaimer. We're going to talk in detail about what I think are the 5 keys to getting a fair property division, but there is no substitute for getting a thorough consultation about your specific situation with a very good divorce attorney. So get educated. That's a very, very good thing to do, but what you don't want to do is make the mistake of thinking you can sort of do it yourself. If you have complex property issues, you really want to get a good lawyer. So enough of the disclaimer. Let's get on to the 5 keys of property division in Texas. So the first key that people are a little surprised by sometimes is that property division in Texas is not necessarily 50-50. Texas is a community property state, and many community property states, for example, California, the property division is by statute 50-50 automatically. The judge has no discretion to divide the community property in any way other than 50-50. That is absolutely not the case in Texas. In Texas, there is a statute directly on this point, and that statute says that the judge shall divide the community property in a manner the court deems just and right. So what does this mean? This means that the judge has almost unfettered discretion in dividing up the community property. Not separate property, and we'll talk about that a little bit later, but in terms of the community property, the judge has the authority and in fact, the direction from the family code to divide the property in whatever way the judge believes is fair. That means different things to different judges, and it means different things based on the facts. So let's talk a little bit about how that plays out in court. So what is a disproportionate division? A disproportionate division is when one spouse is awarded more than half of the community property. That disproportionate division can be 51-49, it can be 55-45, in some cases it can be 60-40, in rare cases it can be even more disproportionate than 60-40. So that's what a disproportionate division is. It's just whenever the judge divides the property in a way that is not 50-50. So there are a lot of different factors that can lead a judge to believe that that a case is one that it's not fair to do a 50-50 division. The issue that most commonly clients will ask me about or will even expect that they'll get a dramatically disproportionate division. The biggest one that people will bring up is fault. They will assume, and probably the most common fault reason that people will assume gives them a really good chance for a disproportionate division is, for example, if one spouse has an affair and the other spouse files for divorce, they sometimes will assume, well, I should get everything or almost everything, or at least a whole lot more than half, because they're at fault and they're the reason for the divorce. And that can sometimes be a reason that judges will do a disproportionate division, but it is not nearly as common a reason as you think. And there are some other reasons that are much more common that lead to disproportionate divisions. Let's talk a little about those right now. So the most common reason for a disproportionate property division is what's called disparity in earning capacity. That's a fancy way of saying one spouse makes a whole lot more income than the other spouse. That's the number one reason that leads to a very disproportionate property division. And by the way, I'll have sometimes the question of, well, what is a disproportionate division? And like I said, that means different things to different judges, and obviously facts are different in every case. But most lawyers and most judges would agree that if you have really bad facts and one that makes the judge think, well, I'm really going to be disproportionate to one side, 60-40 is considered a pretty disproportionate division. There are, like I said, certainly different facts in every case, and there can be bigger disproportionate divisions than that. But 60-40 is considered a pretty disproportionate division. Now, that's, as I said, the number one reason for disproportionate divisions. And by the way, what I'm telling you here about common reasons, this is not in a statute anywhere. This is not in case law anywhere. This is my experience, and I would say the experience of most divorce lawyers, that these are the most common reasons, the biggest variables that will lead judges to do disproportionate division.